SJC-11807, George Schussel, and another be Commissioner of Revenue.
Mr. DeBento, good morning.
Thank you. Good morning. Excuse me. This is an appeal from a decision of the Appellate Tax Board upholding a double tax assessment, which translates, of course, into a 100% penalty assessment, imposed by the Commissioner of Revenue pursuant to a determination that the 3 tax returns that were filed for the years 93, 94, and 95 were fraudulent within the meaning of Section 28 of Chapter 62C. These were joint returns filed by a married couple, George and Sandra Schussel, and they are the appellants here. The case began with a notice of failure to file these 3 returns, and the notice is dated May 15, 07.
So that was after his conviction in federal court?
Yes, and that explains, of course, why the delay. The notice, he was convicted by a jury in the federal court of an evasion for 95, but the evidence and exhibits also showed that there were understatements in 93 and 94.
I mean, he was convicted of conspiracy for a period of time from, what, 88 to... Anyway.
Yes, but not a conspiracy to evade taxes, just a general conspiracy to impair the determination of taxes, the calculation of taxes.
But the evidence was that there was understatements for these years in question.
Yes, yes, there was some evidence that there were understatements, yes. But there was no conclusion by the revenue officer, by the expert revenue officer, as to what the understatement exactly was. So that, and I should point out, the notice of failure to file was sent to the taxpayers' lawyers and tax preparers, O'Donnell and Tessitore, who practice here in Lexington. And of course, the delay, as I've said, is caused by the fact that it did not come to light, nothing came to light until January 25 of 2007, when the conviction occurred. Although there was lots of publicity about the case before that time. And also, we must bear in mind that the Commonwealth would have been also notified under the well-known protocol now, where federal and state governments exchange information in this area. But so that there would, no one would be surprised then to see me take out a copy of the return themselves with one of the pages in bold letters, which I'll get to. But I do want to point out, I'm looking at the 95 return in this case. I do want to point out that the address of the taxpayer shown in the heading of the return is O'Donnell and Tessitore, the tax preparers. The very bottom of it, which doesn't show on this, as it shows better on the 93 return, the very bottom of it says, "See attached statement." And then, when we go to the second page, of course, it's signed by the preparers, and again, it says, "See attached statement." And then we go to the attached statement, which is set out all in one page in big black bold letters, saying the taxpayer is currently a party to a criminal tax case brought by the U.S. Attorney's Office in the District of Massachusetts, and it gives the docket number.
Now, are you saying that that has some significance in connection with determining whether or not the 95 return was fraudulent?
Oh, yes. Oh, yes, because there's a full disclosure. If you don't believe the numbers here, then go to this case and find the numbers that do not appear on this return.
Okay.
There's a disclosure. That's the point I'm making.
But his representation was that his gross income was as stated in the return.
Well, see, now that, wherever I go here, the Appellate Tax Board, the attorneys for the government, for the department, for the commissioner, all say the same thing, that the fraud here lies in the fact that he used the same fraudulent numbers that were on the federal return.
So I take it what you're saying is that, if you look at the numbers on the return, they are what they are. If you look at the rider, what it essentially is saying, that it's almost like an implied concession that there's a dispute about these numbers, and I acknowledge that I may be responsible for paying a tax on some other number, but I believe that my tax is on the number as stated in the return, but these are in dispute, and therefore that disclosure undermines any possibility of a fraud finding.
That's about it, but I'd like to emphasize a different point, another point. The return as filed as a non-resident return is accurate.
But you're not appealing the fact that everybody has found that your clients were residents.
No, I'm not, but I'm not agreeing that that's a, as the brief says, that's a highly it's fact intensive, so to speak.
Well, wasn't that the issue that was litigated before?
Yes, as to whether
whether they were residents or non-residents, and whether they understood they were residents and essentially willfully failed to file as residents.
There is no finding, if I'm understanding your question correctly, there is no finding that the claim of non-residency was itself fraudulent, nor could there be, because there was a full day of testimony on the issue, this is a client who comes into a fact-finding body or even an appellate body facing headwinds. I mean, he has been convicted of tax evasion, and the Appellate Tax Board found that he was not believable and based it in large part on the basis of his conviction. But the point I make here is that as a non-resident return, it's fully accurate because
Or it may not be accurate, but it's not fraudulent.
it's accurate.
But the point was they were in fact residents.
If they were, yes, but as a non-resident return, if they're in fact non-residents, which that was lost, I mean.
But let me ask you this, on the return, is the amount of their federal income properly stated?
I can't, let me say, I think the answer to your question is yes. What happened was, and everybody knew this because everybody was fully conversant with the facts in the federal prosecution. What was understated and proved to be understated in the federal case, and by the way, the defendants did not defend on the tax. They defended on a statute of limitations issue there. So, but what was proven in the federal case was that the appellants had failed, the taxpayers had failed to report subchapter C corporate dividends, which are not taxable to a non-resident. The non-resident return, as a non-resident return, reported truthfully all Massachusetts source income.
So as a non-resident, the arithmetic, if it's in fact a non-resident return, the arithmetic is correct.
Ah, exactly.
But wait, hold on. 1995 return reports federal income of $1 million.
Yes.
That was proved to be fraudulent.
No. That was accepted in the federal case. There
Federal
was another
income?
$5 million that was received as a dividend from the taxpayers' corporation, which was regrettably a subchapter C Corp. And that was what the government charged as unreported. And by doing that, they were able to collect a double tax.
But why do you say, I understand what you're saying, that $1 million for federal income for a non-resident, right? Mm-hmm.
Yes.
So you would, so it would be fraudulent for your federal income tax, but not for your non-resident state tax,
Yes,
right?
right.
Okay,
Leaving off the dividends was fraudulent federally, not state.
Why do you say that, well, yeah, you're not appealing the fact that your clients were residents, but actually there's nothing fraudulent about that at all? I mean, isn't that...
We lost a factual case. I mean, they still believe to this day, of course, that we're non-residents and remain non-residents. But I certainly...
But isn't the assumption when the commissioner is assessing and the tax board is finding fraudulent returns, that's based on that it was more than wholly inaccurate that they were filing as non-residents, that they were in fact residents? Doesn't that become part and parcel of the fraud?
I don't think so. That's not what I understood that was in the commissioner's mind. The commissioner was simply saying that you are a resident and you should have filed as a resident. And the appellate tax, and therefore I'm charging you with the 100% fraud penalty.
Can I ask you a follow-up?
The appellate tax board.
Please finish your sentence. I'm sorry.
The appellate tax board decided that the fraud lay in the fact that he had not included the federal dividends.
Okay, I get what you're saying, is that it's not a fraud if it turned out that the factual case of his being a resident of New Hampshire found in favor. So, and you couldn't, if he was going to take the position that he's a New Hampshire resident or whatever it was, a non-resident filer, you couldn't add the federal tax because that was a sub C, and you don't do that.
Yes.
Is there another kind of claim that there could have been made but wasn't made, and that the fraud lay in the effort to avoid a tax that was due by claiming fraudulently to be out of state, so as to further the failure to properly report the sub C? Is that a possible claim that wasn't made and therefore was waived?
It's a possible claim. Yes, it is. And as I say, it was a fact-intensive issue. We had the burden of proof. And I think I'd had a better chance if I had had a jury. For example, we have a single fact finder. He made a great point of the relationship between mother and daughter, that the mother on the one hand had written a letter saying how loving the family was, and they brought me into their home here in Linfield, and the daughter is saying, well, I live up in New Hampshire, and I don't see my mother that often. And he thought that that was just a terrible, terrible discrepancy, and he couldn't believe anybody as a result. It was only because he had no understanding of a very loving and caring relationship between mother and daughter, where the daughter found a need for distance.
You put great weight on the fact that this return was prepared by an attorney.
Yes.
What's the consequence of that?
The consequence is that it's not a fraud. The man, the
Meaning that
taxpayer,
whenever a taxpayer has his or her return prepared by an attorney, it cannot be fraudulent?
well,
Regardless of what the taxpayer has told his attorney or her attorney?
Pardon me?
Regardless of what information the taxpayer has supplied the attorney with?
No, the taxpayer has to tell the attorney everything, of course, but in this case, we're talking about the facts of residency, which are very easy of discovery.
Did the board make any findings with respect to what your clients told their attorney?
No, there were no such findings. I would suggest...
Was there a request for findings or a submission of evidence?
No, there were just briefs. They don't do requests for findings. But I do want... There is in my brief, in our brief, there is a citation to the McMurray case in the First Circuit, which, if only that case were decided by this court, I'd just be mailing in my argument. I mean, I don't think we'd have been here, but I mean, it's very, very strong precedent. In that case, the professionals the professional advice was way off, widely dissimilar from what the commissioner thought were the true numbers. And in that case, the taxpayer had the burden of proof, which is not the case here. The government has the burden of proof on fraud. But the burden of proof against the taxpayer and the professional advice wildly off were probably the true values of in dispute.
Is the burden on the taxpayer to present a factual record from which a determination can be made that the attorney was fully informed and accurately informed of the taxpayer's circumstances?
Well, if we're talking about numbers, if we're talking about residency, that's one thing. If we're talking about the numbers, the professional used the numbers that everybody knew that was on the federal return and that was part of the federal case. So there's no question of disclosure as between client and lawyer, none at all. The only question of disclosure perhaps is on the issue of residency, but lawyers who are members of this bar have to be presumed to know the basic facts. And if you look at the record, you'll see that these taxpayers had homes in Florida and New Hampshire that made their Linfield home a hovel by comparison. All their artworks, all their valuable possessions were in Florida and New Hampshire. Even their burial ground was in New Hampshire. But when you see, when you're facing headwinds, it doesn't help. The appellate tax board, the board member found that, oh yeah, well, the burial ground's there, but you didn't say when you put the burial ground there. That was an oversight.
Thank you, Councilman.
Good morning, Your Honors. John Steffen, Assistant Attorney General for the Commissioner of Revenue. I want to start with the language of Section 8 of Chapter 62C, which is the double assessment penalty. It authorizes the Commissioner to impose a double tax if a false or fraudulent return is filed or if a return is filed with an intent to evade taxes.
I mean Section 28.
Excuse me.
28.
28, excuse me.
You said 8, I'm sorry.
Sorry, my apologies. 28, Your Honors.
But, so let me just ask you, though. Mr. Demento says, how can you say it's fraudulent if they file as non-residents, which by itself, maybe you would, except that they've got this rider that says you can look at these other numbers over in the federal court?
I think the answer is absolutely. There are at least two ways in which these returns were false or fraudulent. And the first, and I don't want it to get lost in the shuffle amidst the arithmetic, is the notion that they filed as non-residents.
I mean, just the fact of filing and signing it or having it.
As filing it, claiming to be non-residents when the appellate tax board found at record pages 84 and 85 that they did not have a good faith basis to claim New Hampshire residency. 20 years worth of not filing in Massachusetts and filing no corresponding returns in New Hampshire, together with the other facts that were found by the Appellate Tax Board, establish that there was no good faith basis to claim New Hampshire residency, and thus, regardless of the amount of income that they disclosed in the returns, the mere fact that they were filed as New Hampshire, claiming New Hampshire residency, is false and without good faith basis triggers the implementation of the double assessment.
So having nothing to do with the numbers?
That's an independent basis, which would be sufficient in and of itself. The board found, and the commissioner maintains here, as she did before the appeals court, that the returns were also false in reporting the amount of income that had been determined as part of the federal tax prosecution to be less than the full amount that was earned.
But why isn't the rider at least a disclosure of the fact that there is a dispute that is ongoing? It's before the First Circuit, even after conviction. We may be wrong about the tax we owe, the tax that we claim we owe. We know by being wrong we may have to pay interest and a penalty, but it isn't fraudulent because we've made this disclosure.
I would argue, in fact, that the rider itself is yet another false statement that accompanied these returns, insofar as it purports to say that the amounts or the nature of the income were actually the subject of the appeal. The appeal had nothing to do with the amount or the nature of the income. It concerned whether or not jury instructions were appropriate, whether or not certain privilege documents should be admitted.
Let me ask you this. On the federal return, in the federal case and on the federal return, this issue of whether Massachusetts or New Hampshire doesn't really matter because the federal taxes are going to include those dividends regardless of where you live, right?
That's my understanding, yes. There was no question about domicile such that the facts that were raised here.
Raised in that case at all. So,
correct.
So to both my and Justice Spina's question about why was it fraudulent, because looking at the federal return isn't going to tell the commissioner anything related to domicile at all.
That is correct. But in the course of the domicile argument was made before the Appellate Tax Board. The board issued extensive findings on the domicile issue, and there has been, after those findings were established, there was no challenge made to them either before the appeals court or here. And I would argue that leaves the factual findings on domicile and the legal conclusion that there was no good faith basis to claim otherwise unchallenged and effectively conceded by the taxpayers.
So that's step number one. Let's assume, let's follow your reasoning. So 2 ways that this was false or fraudulent.
At least 2, yes.
Okay. You've got the non-residential thing. Assuming you've established that, it's not appealed, how do you get the amounts then? So now you've got the ability to double assess. Where do the amounts come from?
So the amounts then are coming from the IRS auditing documents that were communicated, were established through the course of the federal prosecution and communicated to the Commissioner of Revenue.
That's the evidence before the board.
That's Form 4549A?
And an accompanying letter, 692, I believe. Those set forth the amounts. The taxes were stipulated to in the course of the Appellate Tax Board proceedings. So in the supplemental agreed statement of facts, there are tax amounts that if residency goes this way, then the tax due shall be this, and so forth. So that was set forth.
Okay, so to Justice Cordy's question, I sort of lost you there. On the amounts, once you get over the residency thing and you take the board's finding that there was no good faith basis to say New Hampshire, it was Massachusetts, then the amounts are not in dispute? Is that what you're saying?
I'm saying then that
the amount of income isn't in dispute?
So the amount of income that was the basis for the calculation was determined in the course of the federal proceedings, both by the IRS audits and in the evidence that was adduced at the federal prosecution. Those figures are incorporated directly into Massachusetts returns because federal gross income is the basis for Massachusetts gross income, and the taxes can then be calculated from that. So I understood Justice Cordy's question to be, if you determine them to be properly residents and you can impose the double tax, what are you doubling? Those are the numbers that you're doubling.
So, and one last question on that.
Certainly.
In the federal, the federal prosecution, the only actual tax year, as I understand it, was 93. 95, excuse me, not 93 or 94. So, but you have numbers for 93, 94, and 95.
That's correct. Because that was part of the IRS audits that were done in the course of the federal investigation of the conspiracy, which, as you pointed out early on, Justice Botsford, was decades long. But you're correct that the prosecution focused on that one loan return, but in part of its conclusions, but the convictions were for both tax evasion and for conspiracy and spanned a number of years, including all of the tax years at issue.
So what do you say is the consequence of any of these returns being prepared by an attorney?
I would say in this instance that it's immaterial to the imposition of the double tax assessment. It certainly is not a shield any more than the rider is. Precisely because, although there is an advice of counsel defense that can be recognized in certain circumstances, none of the elements of that argument are present here in the factual record, and I don't believe actually were made before the Appellate Tax Board and would be
Mr.
waived.
Demento says, however, that there are really no facts that were pertinent that the lawyers didn't know, and that's clear from reading the...
I don't believe that that's necessarily true. If, at a minimum, there needs to be testimony that the taxpayers have made a full disclosure, full and honest disclosure of all the relevant facts, and that the attorneys then provided them with advice on which the taxpayers relied.
And that was never, that kind of testimony was never presented before the commissioner.
That's correct, Your Honor. There was no testimony concerning what information was disclosed to the attorneys, nor was there any testimony by any attorney as to the fact of advice being provided, nor was there any testimony from the taxpayers that they relied on the advice of counsel.
Is there any argument made about relying on counsel, seeking to use this as a defense? Was there any argument before the board?
No, not before the board, Your Honor. And
The appeals court, the first time that
I
came
believe
up?
that was the first time that it arose. Certainly it was not a... these were tied into the rider issue, and there was discussion of two appellate tax board cases, the Skagel case and the Ruggiero case, in ways in which there was a comparison made as to whether or not the taxpayers could hide behind this rider as a defense to the intent. There were findings that were made on that issue and conclusions that this was a case where, like the Ruggiero case, involved a reckless indifference to the obligation to pay taxes, not an honest mistake made in that sense.
In terms of the, just factually, in terms of the inadvertent amnesty notice that was
Yes.
sent, and what's written is that the taxpayers paid the amount assessed. So are we talking now about the difference between the tax and doubling it? Is it the other half of that? Is that what's at issue?
The double tax is the only thing that's left at issue. The
But
amnesty...
it's the doubled part they've paid the underlying tax.
They paid the double tax.
So to back up, the amnesty notice that was issued identified an amount, a tax that was due, all tax due and owing. If they paid that amnesty amount, then they would be entitled to waiver of the amnesty savings amount, which incorporated certain penalties.
Right.
It did not include the double assessed, the sort of 2x, a doubling of the tax.
2.9 million, that included the double assessment, and they're essentially seeking an abatement.
It is correct, they're seeking an abatement, yes. And the commissioner is not seeking to recoup the immediate assessment or jeopardy
Right.
assessment penalties that were...
So
or other
basically, if
fees
they
and
paid 2.9, now. So they're looking to get back 1.45? Is that where we are? No?
875,000 or 900.
I don't have the numbers on
Oh, so
that,
it's
but
not
it
half
is
of, because I thought that was the doubled amount.
the,
It's double
I
plus
don't-
interest. And
yeah, I'm
Oh, I
not
see,
certain,
but
honestly, Your Honor, I apologize. But the amnesty is important to focus on, and just to take the issue we haven't yet talked about, insofar as I don't believe a reasonable argument can be made that the Schussels were actually entitled to amnesty. They make a claim that if the statute is read very narrowly so as to limit this exclusion for tax-related investigations or prosecutions solely to those that concern Massachusetts taxes, that they would then be eligible for amnesty. In that sense, I don't believe that that's supported by the text of the statute, and it certainly isn't supported by the policies and reasonable interpretation of the statutory intent behind it. Unless there are other questions from the court, I'd be happy to rely on our brief.
All right, thank you. Thank you.